kind of want to start with a question that I'm sure is on a lot of Iowans' minds, which is, how does this opinion, if at all, impact Iowans' access to abortion today?
It is questionable whether the 24-hour waiting period is in place or not. Other than that, it doesn't affect our rights today. What it does is leave open the ability of the legislature and governor to pass a statute to ban abortion in the coming weeks, such if the U.S. Supreme Court decision is overturned.
And I know that this is a lengthy opinion. It's 182 pages. So for those of us who are not lawyers, if you can kind of walk us through, really what's at issue here. What did the majority of justices take issue with in that 2018 opinion that ultimately led to them reversing it today?
Yes. Well, the 2018 opinion said that there was a right to abortion in the Iowa Constitution under both the clause that says you can't deprive someone of liberty without due process of law, and the clause involving equality. And the basis of that in both decisions was an acknowledgement that women can't be fully free in our society if they are forced to carry pregnancies. And that what women need to be able to fully participate, to have liberty, to be equal, is to be able to control when, where, and if to have children. And taking that right away from women takes away their liberty and takes away their equality. The majority plurality opinion today rejects all of that reasoning, really minimizes the equality issue to try to claim that what we're saying is that women can't have children and be free, which is not what the earlier opinion said at all, and basically said the only way you decide if something is a liberty interest is if it's historically protected. And while an abortion was banned in the 1800s, at least post-quickening, and so the question really is it abortion itself, or is bodily integrity what the issue is? And if bodily integrity is what the issue is, that is long recognized and supported in our nation's history.
And I know we've seen a number of challenges, injunctions from Planned Parenthood of the Heartland, throughout this process. I guess, do you foresee a challenge to this, or what could that look like? Would that potentially be a new lawsuit? Would that be an injunction? I guess, what, if anything, could those maybe on the other side of this do, I guess, in response to maybe challenge what's happening today?
Well, I don't think there's going to be much relief from the courts with the federal court or this court in these opinions. I think where the action will be is on the streets, and the legislature and the voting booth and the organizing are the better, more likely ways of overturning this or changing this. The court, the court is saying it's going to review, it's saying it will review abortion regulations either under a test called the undue burden test, which came from Planned Parenthood versus Casey in the U.S. Supreme Court in 1992, which said that abortion regulations are okay unless they provide such a burden to women on their right to get an abortion that they basically can't get it. Or whether it's the rational basis test, which is there any rationale, legitimate rationale that could support this law, even if it's not the rationale the legislature gave. That's why they're sending it back down. But I think they're also really sending it down to wait for the U.S. Supreme Court's ruling that's expected in the next few weeks that we all believe is going to overturn Casey, at least if the draft opinion that was leaked is anywhere near the final decision.
And in today's opinion, we're seeing a court today re-examine a decision, an opinion by a court just 4 years ago. Talk to me about, is this a common practice in high courts, or does this kind of rank more unusual, I guess, for this window of time to exist?
It's unusual. While certainly courts overturn earlier opinions, some of our great civil rights cases involve that. Brown versus the Board of Ed in 1954, I believe, overturned Plessy versus Ferguson from the 1890s. And the laws criminalizing consensual sodomy were upheld in 1986 and reversed and overturned in 2004. But usually things have happened in between. The law on the ground has changed. The facts on the ground have changed. The only thing that has changed in the Iowa Supreme Court is who's on the court. And that leaves the court open to some people viewing the decisions not as what the law requires, but what just a majority of the court can pass. And that it's not about constitutional law, it's about the views of the justices.
And I guess, is there any thought behind this setting any type of precedent, whether that's before a high court, lower courts, I guess, that this issues outside of abortion that you see this potentially impacting with this decision today?
Well, it's reiterating a position several of the justices have taken, that you look at that you interpret the laws and the Constitution as written at the and as understood at the time they were written, and give no room for how we've now viewed things differently. It's sometimes called a living Constitution versus so-called original intent. I wonder if it's really original intent, but so other things that have rights that have been recognized could be at stake. Then again, certainly in Justice Mansfield's opinion, he talks about how much, or he mentions that Varnum, the marriage equality case, has been so well respected now and is probably not at risk. But you wonder where else they could go. This court is not quite as right-wing as the U.S. Supreme Court, where a large body of law could be overturned based on Justice Alito's draft. But the governor did take steps to rest a majority of the Judicial Appointing Committee. So our merit selection, which was supposed to not be political, she now has a majority of the members of the commission. And so it's leaving room for more political appointees and not just merit selection. I'm not questioning the merits and the qualifications of any justice on the Iowa Supreme Court, but it leaves it open for more political manipulation.
And I guess to kind of flip it around and so people understand, I guess, another side of this, what would it take here in Iowa at this point for abortion to become illegal, for it to be banned, and especially with kind of that Roe v. Wade case overhanging us in the coming weeks?
I would say it couldn't be until the Roe v. Wade decision, until the Mississippi case is decided by the U.S. Supreme Court. At that point, I expect the governor will call a special session and Iowa will become like Tennessee, Oklahoma, Texas, with a total ban and putting women's lives at risk. And that's the important thing to recognize, that when you ban abortion, you don't stop abortion. So women will get an abortion either way. Some will be helped to get out of state where it's safe and legal. Other people will self-abort and with the risks accompanying it. And depending on whether they make a criminal statute for the woman herself, you'll start seeing miscarriages investigated by prosecutors to see were they really a miscarriage or was it an abortion. And women who have miscarriages, truly miscarriages, will end up in prison. That's happening in other countries. Also, depending on the wording of whatever ban they put in, there's just an article in the New York Times about how Poland's ban has put women's lives at risk because doctors are afraid to remove fetuses that are putting a woman's life at risk because they're afraid of prosecution, and women have been dying.
And I guess I know part of today's opinion impacts that district court decision in 2020. What do you anticipate that could look like, the timeline for people to understand, especially with Roe v. Wade looming?
I expect, usually the court puts out what they call a precipice, a sort of final order that says this is the order, go ahead and do what you need to do, about 3 weeks after an opinion comes out. So if they left something out, they need to amend it, whatever, that can be there. And Planned Parenthood could move for reconsideration, but the likelihood of that being successful, I don't see anything there. So then the district court will schedule a hearing, and so it'll take a bit of time. And I think by the time that all happens, the U.S. Supreme Court will have ruled, and the governor will probably get an abortion ban passed, and nobody will care about 24 hours because it'll be impossible.
I believe that's kind of the questions I had for you. Anything that I left out that you'd want Iowans to take away from today, I guess?
Well, this is one of the first bombs falling, and we have to react. We can't just be complacent now. We're being told that we don't have our rights, and it's not going to impact me. I'm not going to have an unwanted pregnancy at my age, but my students, my daughter, these laws passed around the country and around Iowa are going to severely impact many women people know and the men who love them. And so we've got to be involved and do what we can. And we have to realize that essentially abortion is on the ballot in 2022.
Sally, thank you again for sharing your expertise with us. We appreciate it.
You're welcome.
Thank you.